Judgment in the appeal, Hayes against Willoughby.
I'll ask Lord Sumption to explain the decision and summarise the basis for it.
Under the Protection from Harassment Act, 1997, harassment is both a civil wrong and a crime. It was created by statute to deal with those who persistently and deliberately engage in unreasonable and oppressive conduct targeted at another person which is calculated to cause that person distress. One of the most notorious forms of harassment is stalking, particularly the stalking of women. But it has a much wider application than that, and in its short history has been applied to a number of other forms of oppressive, targeted campaigns against individuals. The potentially wide scope of the statutory prohibition of harassment is, however, limited by Section 1(3) of the Act. This important provision says, in broad summary, that the prohibition does not apply to conduct which is pursued for the purpose of preventing or detecting crime, or in accordance with some statute or rule of law, or which is reasonable. In this case, the issue before the court is the scope of the exception for conduct which is pursued for the purpose of preventing or detecting crime. The defendant, Mr. Willoughby, once worked for an IT company run by the claimant, Mr. Hayes. Since 2003, he has been engaged in a prolonged vendetta against Mr. Hayes. This has taken the form of persistent allegations that Mr. Hayes was guilty of fraud, embezzlement and tax evasion in the management of his companies, mainly in the accounting year 2002-3. Mr. Willoughby pressed these allegations in the course of no less than 400 communications between himself and the official receiver alone, in addition to communications with the Department of Trade and Industry, the police, and other official bodies. The official receiver obtained access to the records of the company. The DTI began 2 statutory investigations of the companies. The police also investigated the allegations. All of them concluded that there was nothing in them. They passed on their conclusions to Mr. Willoughby, but his response was to complain that they had not been sufficiently astute or thorough and should try harder. Eventually, the point was reached where most of the official bodies in question refused to have anything more to do with him. The judge who tried this case concluded that this was harassment, and before this court, that has not been challenged. The question is whether Mr. Willoughby was entitled to invoke the defence that he was acting for the purpose of preventing or detecting crime. The judge considered that up to 2007, when the official receiver concluded his investigations, there was a reasonable basis for Mr. Willoughby's suspicions and for his campaign against Mr. Hayes. Thereafter, the judge considered Mr. Willoughby's persistence in his campaign to be unreasonable, because his allegations had been investigated by those with access to the evidence and found to be without foundation, and because once the various official bodies had closed their investigations and in most cases refused to deal with Mr. Willoughby anymore, his campaign was not going to lead anywhere. The judge nevertheless found in Mr. Willoughby's favour because he considered that, however unreasonably, Mr. Willoughby genuinely believed that Mr. Hayes was a crook and that his campaign was a legitimate way of exposing him. The judge considered that that was enough to satisfy the statute, and that it wasn't necessary for Mr. Willoughby to show that his belief was reasonable. The Court of Appeal allowed the appeal. The Supreme Court considers, by a majority, Lord Reed dissenting, that on the facts found by the judge, Mr. Willoughby was not entitled to the defence that he was acting to prevent or detect crime. Most of those who invoke this defence will be public bodies with public duties, such as the police. They are subject to the ordinary constraints imposed by public law, including the usual requirement that the conduct should be rational. But the right to take action to prevent or detect crime is not limited to public bodies. Private individuals are entitled to do so, even without a statutory remit, provided that they act within the law. Private individuals are not, however, subject to the same constraints of public law as official bodies. In the view of the majority of this court, it cannot have been Parliament's intention that there should be no limits on conduct intended to prevent or detect crime, no matter how irrational, perverse, or abusive, simply because the person in question considers that there is a potential crime calling for prevention or an actual one calling for detection. The statutory defence does not require the alleged harasser to show that his allegations or his conduct were objectively reasonable. The defence depends on whether the alleged harasser genuinely intended to prevent or detect crime. But this is subject to the important proviso that this view must not only be genuine, it must also be rational. That means that the alleged harasser must have applied his mind to the matter and must have acted in good faith and without arbitrariness, capriciousness, or reasoning so defiant of logic as to be perverse. He must have thought through the material suggesting criminality and formed the view that his proposed course of conduct was an appropriate way of preventing or detecting it. If he has done this, then the court will not reject the defence simply because it considers that a reasonable man would have acted differently. But if he has not done it, then he cannot be said to have had the relevant purpose, nor will there be any sufficient connection between his belief and his behaviour. In this case, from 2007 onward, on the judge's findings of primary fact, Mr. Willoughby's conduct was irrational. It was incapable of furthering the prevention or detection of crime. In the judge's words, his conviction of Mr. Hayes's guilt now preceded rather than followed any objective assessment of the evidence. It therefore amounted to unlawful harassment, and Mr. Hayes is entitled to an injunction and to damages if he can establish that he has suffered any. In a dissenting judgment, Lord Reid considers that the judge was right to allow Mr. Willoughby the benefit of the defence. In his view, the only statutory requirement is that the alleged harasser should genuinely have acted for the purpose of preventing or detecting crime. A test of rationality is not to be found in the Act, and it is not a necessary implication, nor is it a desirable one, given the practical difficulties that it would occasion in directing juries in criminal cases on the state of mind required to give rise to a defence. In the result, however, the Supreme Court affirms the order of the Court of Appeal, although for somewhat different reasons.
The Court will now adjourn.